right. Good morning. Good afternoon, everybody. Thank you for being here today. I still see some people joining. I see a lot of familiar names. So welcome everybody. See some new names as well. So welcome if you are new. Welcome to Haynsworth's employment law webinar series. For those of you who are new, our employment law team here at HSB does a regular webinar series where we spend an hour during the lunch break talking about employment law updates. Sometimes we dive into specific topics. Today, I'm going to be doing a general update on several things that are happening in the employment law world, and we'll dive into those in a few. But before we get started, just a couple of housekeeping items. You see some information on the screen there about HSB. One interesting thing to note is that we have fairly recently expanded into the North Carolina market with an office in Raleigh. So we're now more of a Carolinas firm than just a South Carolina firm. I think most of you are probably subscribed to our blog, but if not, we send out information about these webinars, and we also have blog posts in between the webinars about different employment law topics. It's a good way to keep up to date for those in the HR field. Today's presentation, as I was sort of putting it together, I realized there's not a ton of information in here today, so I think we're going to have some time at the end for a little bit of Q&A if there's other things on your mind or other issues you want to ask me about. As we go through the presentation, feel free to utilize the Q&A or the chat feature in the Zoom platform to answer those. And I may try to monitor as we go along. And some of my colleagues may jump in and answer questions as well. But to the extent that we don't, I think we will have some time at the end for Q&A. So don't be afraid to ask questions, even if about something different than what we're going to talk about. And then the presentation slides and recording will be shared with you following the event, and you will receive credit for this course for Sherman HRCI. So as I mentioned, today we are sort of doing a legal hot topics presentation. I like doing these because we get to hit a number of different things. Some of them may be applicable to you and your organization right now. Some of them may not, but we're not going to do a deep dive into any one thing. So hopefully there's something that everybody can take away from today's presentation. I did one of these back in February. So kind of the idea being a sort of twice a year type of thing. A lot of the February presentation was focused on legislative updates. Today's presentation is a little bit more all over the place. But we definitely have some things that have happened between now and February. And I kept a couple of slides from the February presentation in here as well, just in case anybody missed that or we have anybody new. But this is a few of the things that we're going to talk about today. So we can go ahead and dive right in. I did this last time, and I thought it might be helpful just to start on a very macro level of what's going on in the economy currently. For those of you that follow the broader economy, the Federal Reserve has been trying to cool inflation by raising interest rates. There was an announcement from the Federal Reserve Chairman this week that more interest rate hikes are coming. And as I note here, that's going to decrease demand and potentially force us into a slowing down of the economy. One of the interesting things is that the labor market has been the one thing that has been steadfastly strong over the last couple of years. One of the things that the Federal Reserve was hoping to do was to see that the wage pressure would ease a little bit and get unemployment back to sort of a healthy level. The unemployment rate nationwide is is 3.7%. It's very, very low. It's a very, very tight labor market, as I'm sure that many of you are very familiar with if you're out there recruiting right now. And economists kind of think that's almost too low. I mean, you certainly think of the unemployment rate being that low is a good thing, and it is for workers, but it's certainly can be a problem for management. And wage pressure just remains really, really high with inflation kind of being stubbornly high. Workers are demanding more as far as pay, and if you're recruiting workers, they are definitely going to be looking for pay increases, and that creates all types of pay issues at your organization. And so that's kind of one thing to keep an eye on in the broader economy right now. So I put a slide in here since it is June of two things. June is Pride Month, and we also just celebrated on Monday the Juneteenth federal holiday. I think last year was the first year it was a federal holiday, a federal bank holiday, that is, celebrating the emancipation of slaves in the United States. So two sort of current events that you might have dealt with from an HR perspective. As far as Juneteenth goes, I think I was trying to look up the most recent statistics, and it looked like SHRM had provided a statistic that something like 40% of private organizations now offer Juneteenth as a paid holiday. And I think originally organizations were sort of doing that as part of DEI efforts. And now with it being a federal holiday, I think it's more of the expectation for employees that be time off. So that's an interesting thing to think about, that if that's not something that your organization's doing. I'd be curious in the chat if anybody wants to weigh in on whether or not they've offered that as a holiday, and also if they're doing anything specific for Pride Month as part of DEI efforts or otherwise. I have had a few questions this month from organizations with respect to each of those. One question in regards to Juneteenth is, since it's a federal holiday, does our private organization have to give it as a day off? And the answer to that is no. Certainly think there's of course valid reasons for doing that. And then with respect to Pride Month, you may have issues as an organization if you're doing something as an organization to celebrate Pride Month, or employees are asking you as an organization to do something for Pride Month, whether that's sending out marketing materials or intercompany announcements or things like that. And I've even seen pushback from some workers in regards to companies' recognition of it. Everything is kind of a culture war in today's world, so there's inevitably going to be issues. But I think the key thing to keep in mind with respect to both Juneteenth and Pride Month is that both events are associated traditionally with protected classes in the workplace. And so when you're making decisions in regards to how your organization is going to treat those events, you need to keep in mind what you're doing for other events as well, other holidays, other organizations that maybe want the company to recognize them and things like that. So just keep that in mind. Nothing really further on that for today's purposes, but given that it's June, I thought it would be appropriate to include that. So 2023, I think so far has been the year of artificial intelligence. And I'm sure you've read something about artificial intelligence, either in your professional circles or even in your personal life, whether you've messed around with the chat bot or something like that. But this seems to be the sort of next big thing. People are certainly comparing it to the way the internet reshaped the world. People think artificial intelligence can do that as well. There's interesting anecdotes. Some of you may have seen this story about the first person to be represented by an AI lawyer, some software that sort of filed briefs and stuff like that for a party in litigation, and it did not go very well for that party. But it's obviously very early stages of all of this. There's companies making a ton of money off artificial intelligence, and other companies that aren't in the artificial intelligence space, even like our law firm, figuring out, okay, how can we use it? Should we use it? If we do use it, what are the legal parameters around it? And, this could be a whole seminar courses on this, but I think that, and everybody feel free to weigh in here, but I think that right now, the key areas with respect to AI for HR consist of employee monitoring, recruiting, and data privacy. And we'll talk a little bit about each of those things in the next couple of slides. So the EEOC has released a technical assistance document in regards to the EEOC's interpretation of using AI in the workplace and maintaining equal employment opportunity status for everyone. And essentially, that document is worth a read. But essentially, the big takeaway is that there's nothing inherently wrong with the use of AI with respect to employment-based practices. So if you use AI to screen candidates in the recruitment process, for instance, that's okay. That's not illegal to do that. But ultimately, the employer is responsible for what AI does. So if you're using an AI as a screening mechanism to search resumes, or a chat bot for interviews, or things like that, and the effect of that is to have a discriminatory impact on a certain protected class, it's not going to be, from the EEOC's perspective, it's not going to be a valid defense for the company to come forward and say, well, we didn't know, that wasn't our intention. We didn't know that was actually happening. We just utilized the software to help us. If it's your company, if it's a candidate hiring for your company, you're responsible for your company's actions. So that's where understanding how to use AI is of critical importance. And that's why they say that individuals who can understand AI and understand how to use it and understand how to talk to it are going to be very valuable. And I imagine most companies are going to be looking for those individuals in the coming years to employ them as part of their organization. I made reference to a couple of examples, but for those of you who are curious and who might not have put a lot of thought into this yet for whatever reason, the technical assistance document does give some examples of things that HR might be using artificial intelligence for. I mentioned resume scanners. So, and this is called AI, but a lot of these products are sort of already out there, and companies use them, and they may not think of them as AI. They're just, software, recruiting software. And one thing is, a resume scanner that would scan job applications, scan resumes, and screen out candidates or prioritize candidates based on certain keywords. And I just came up with a couple here that might be relevant, like magna cum laude, Six Sigma, engineering, things like that would be on their face reasonable things to screen for an applicant in a resume or an application. Chat bots would be more used probably once you get past that first phase and maybe there's a quote unquote interview. as a first round with a chat bot before the person gets to interviewing with a real live person. And most of you have familiarity with using chat bots on internet websites, whether it's, I feel like I'm always, bank or credit cards come to mind as one where, you call up the bank or the credit card and they say, use the chat feature on our website, and the chat feature sort of says, what can I help you with today? You enter in a response. Based on that response, they give you a couple of options and it filters down that way. Theoretically, an employee interview could be handled that same way with this technology, where the person that, the chatbot might say, do you have at least 5 years experience in this field? If that's a job requirement. If the person responds no, maybe they won't be considered. And that's taking work away from the recruiter or the person at the organization who's responsible for it. So in some ways, there's a lot of talk about this replacing jobs. And I think certainly artificial intelligence will displace some jobs. But in a lot of ways, it'll make jobs a lot easier. So it's certainly an interesting development. They had something on there about video interviewing software, and that's basically where you evaluate candidates based on facial expression and speech. Some of you have probably seen this sort of face and speech recognition technology. They use it in iPhones and things like that. Apparently, it can be used for job interview purposes as well. This one I'm a little less sure about. If anybody can think of why that would be a particularly great use in a job interview, feel free to mention it in the chat. But that's one of the others mentioned in the EEOC document. So testing software has been around for a while. And you might not have thought about it like artificial intelligence, but this just could be a traditional test like multiple choice. But I think where the AI side of things coming from is this sort of more complex video game like testing. Maybe you are hiring an engineer for a specific position, and you're utilizing the software that essentially puts the engineer into a problem-solving game, a position of so-and-so process is not working efficiently. Here's the information that you need. What would you do about it? And it's sort of role-playing scenarios, sort of an aptitude test, essentially. Those are becoming increasingly complex and increasingly popular, and could be very valuable as an aptitude test. Those are all sort of related to recruiting, interviewing, things like that. But artificial intelligence can certainly also be used with respect to current employees. And I think the biggest use of that right now is with respect to monitoring productivity. This became a really hot button issue when more and more workers began to work from home during the pandemic. And the question on everybody's mind is, well, if our workforce is at home and not in the office, how do we adequately measure what they're doing at home and whether they're being productive? And there is a lot of software out there that can do this. Whether it monitors keystrokes or active time on a computer, things like that, is pretty advanced as far as what it's doing, and that one sort of raises a lot of, so it certainly raises some legal issues. The National Labor Relations Board has been interested in that as a potential unfair employment practice, but it also, I think, more fundamentally raises ethical considerations as well as general human resource issues. I don't think that anyone likes to feel like they are being watched or monitored all the time. Even if you're in the workplace with security cameras or things like that, there may be an understanding that you could be watched in the event of of an accident or something like that, an incident in the workplace. But this sort of idea of 365 monitoring of what you're doing on your computer at all times does not sit well with most people. And so that's going to be one to keep an eye on for sure. And if anybody has any experience with using that or any of these, please, feel free to share it in the chat. All right. Happy to answer questions about artificial intelligence. We're in the early days of it, certainly, but I think we're going to be hearing more and more about that. I think probably, at some point in time, we'll be doing a webinar just on that topic as more companies adopt those policies. If you're, I've seen model policies from SHRM and things like that out there. So I know some companies are certainly implementing them. So switching to another topic, the world of non-compete agreements continues to be in flux or really under attack. Recently, just on May 30th, the National Labor Relations Board General Counsel issued a memo, which, for those of you that don't have a lot of interaction with the National Labor Relations Board, it's sort of the head lawyer at the board's opinion, legal opinion on something and what stance they're going to take with respect to certain claims. The General Counsel issued a memo with the opinion that most non-competes violate the National Labor Relations Act, which made big news. It was sort of very surprising. It's not something that the National Labor Relations Board has traditionally waded into, but it's the most recent in a long line of attacks on non-compete agreements. And what was said is that in the memo, in my view, the proper maintenance and enforcement of a non-compete provision that reasonably tends to chill employees from engaging in Section 7 activity violates Section 8A1 unless the provision is narrowly tailored to special circumstances justifying the infringement on employees' rights. So a couple of things to break down there. You see the reference to Section 7 activity, and under this interpretation, the National Labor Relations Act and those sections apply to non-unionized workplaces. So this is not something that you can just dismiss as not potentially impacting your workplace as a non-union organization. And basically, I think what the reasoning or the idea is that if an employee is under a non-compete agreement and feels like they can't leave that employer because they're prohibited from doing so by this burdensome non-compete agreement, then that chills their right to engage in protected employment activity. And so you also see there that unless the provision is narrowly tailored to special circumstances, they go on to state further in there that something like protection of trade secrets or something like that, which they've sort of grouped into this, would still be valid. It's important to note a couple of things here at the outset. This is not law. This does not apply to any organization yet as a binding directive of any kind. This is just a lawyer at the National Labor Relations Board sort of formal opinion on it. I imagine that it will come up at some point in litigation before the board. If this administration stays around long enough and this board under its current structure stays around long enough, I imagine it will get to the point where it will be challenged, and not sure the labor board has the authority to do it. But There are many states in the U.S. That have moved to outlaw non-competes in their state. It has traditionally been a state-by-state issue, which creates its own set of problems. California, for instance, has outlawed non-competes a long time ago. I was at a conference 2 weeks ago and was talking to an employment lawyer in San Francisco, and he was telling me that I was telling him about my practice and the fact that I did some competition law, and he was saying that that has not existed as even a thing in the employment practice for 15 or 20 years in California, which is kind of wild to think about. And so we sort of have this patchwork of state laws currently, and that makes it very, very difficult for organizations that have employers employed all over the country, is figuring out where can I have a non-compete, where can I not. So if you'll remember, the Federal Trade Commission at the federal level has also issued a proposed rule banning non-competes nationwide. This is a proposed rule as of right now. I am a little bit skeptical that rule will ever take effect. I think that the Federal Trade Commission probably does not have the authority to do that. That's just my opinion. To the extent this does become a final rule, it will certainly be challenged in court, and ultimately a judge will decide whether the Federal Trade Commission has the authority to do that. But like I said, it's always been a state-by-state issue. You see these efforts between the NLRB and the FTC to regulate it at the federal level. I think to some extent, if the U.S. Congress would just pass a law on non-competes, that might be the best thing for our labor economy, just so there's consistency and understanding. Right now, they're very hard to understand. One of my colleagues here at HSB has worked on a model non-compete law to be presented to states that state legislatures could pass, which would bring some consistency to the issue. But right now, it's kind of the Wild West, and we've got more questions than answers. I also note here that the memo was silent on customer non-solicitations. So theoretically, those would still be valid even under their interpretation. So still enforceable in South Carolina and generally across the South, as I'm sure many of you know that employ these non-competes, but there's sort of increasingly their scrutiny of their use. Like I said, California got rid of them 15 or 20 years ago, and a lot of people think it's one of the best things that's happened to the tech sector in California, because employees can sort of freely move. And from a management perspective, that causes issues. But even if non-competes were outlawed, there are still other ways to protect your business. And there's certainly nothing urgent that needs to be done if you've got non-competes in place with key employees. But it's one of those things that you should keep your eye on, and it might be time to start thinking about how your organization is using them, and if that's sort of a key part of your business protection and employee retention strategies, that it might be time from an operational perspective to start thinking about other ways to do that. So another one to keep an eye on. Crown Act laws. CROWN stands for Creating a Respectful and Open World for Natural Hair. I did not include this in my February legislative update, but these laws were in front of several legislatures during this past term, and you'll see here California, Illinois, Colorado, Connecticut, Massachusetts, New York, and Tennessee have all passed these laws. And I think the big state that was considering it, I don't think adopted it, was Texas. But it's basically a law that prohibits race and national origin based hair discrimination. So discrimination based on hairstyles such as locks, twists, braids, or other hair that's associated with a specific race. And, you know, if you are discriminating against someone based upon their braids or the way their hair looks, arguably that could already be covered as a Title VII race discrimination claim or national origin discrimination claim, because you could view that as evidence of one of those things. But these Crown laws would make that sort of very, very specific, a little bit like in the way that, pregnant workers have been for some things covered under some laws, but, pregnancy accommodation laws, pregnancy discrimination laws sort of make it very clear that, pregnancy is its own class. These laws make clear that hair-based discrimination is a protected class as well. So if you have workers in states with Crown laws, or even if you don't, based on what I said about it perhaps being covered under Title VII anyway, it's good to review policies and procedures on grooming and personal appearance to see if they need to be updated. I think dress code policies, personal appearance policies, grooming policies are one area that's kind of ripe for the EOC to look at a handbook and say that the policies are discriminatory in some way. So even if you don't have a Crown law in your jurisdiction, which we don't in South Carolina yet, I think that's a good idea. And one other interesting note about that is that there seems to be, I've been noticing an increasing movement to across the states to add new protected classes in the field of employment discrimination. I think California has recognized political affiliation as a protected class, which people have been calling for on sort of both sides of the aisle for a while now because of the way our politics are. But I saw New York City was considering passing an ordinance on weight and height discrimination. So no real movement in South Carolina on additional protected classes that I'm aware of. But that is something that's happening nationwide, just as FYI. All right. On to another topic. The U.S. Supreme Court is always an interesting thing to keep an eye on. They usually, during their term, have one or two cases before the court that have an impact on employment law. And that's no different for this term. They have, I believe, heard oral arguments in this case, Groff versus DeJoy, have certainly not issued a decision yet in it. But it's the only like true employment law case that they're going to decide this term, and it concerns religious accommodations. And the facts of the case are pretty straightforward. The former employee that brought the lawsuit was a mail carrier for the U.S. Postal Service, and he observed the Sabbath and requested that he not be required to work on Sundays. And so basically said, don't schedule me on Sundays. I'll schedule routes on any other days, but I'm not, I can't work on Sundays because I take the day off. And, critical from the employer defendant's perspective was the fact that this was a very rural area. I think it was out in central Pennsylvania, maybe, but a very rural area with a very small staff. And the employer basically said, at least at first, I think it sort of granted the accommodation or said it would try its best. We'll do what we can. Eventually, and they told him they couldn't guarantee an accommodation. Eventually, he started to be scheduled for more times on Sundays, and got into kind of a dispute with the employer about it. The employer disciplined him for not working on Sundays for scheduled routes, even though they said they were doing the best to arrange it. And he ultimately quit, and claimed, constructive discharge and a violation of Title VII, saying he was denied a religious accommodation. And the employer's defense in the case is basically, look, we've got a very small staff of 2 or 3 others, and if you're not working on Sunday, that's really overburdening our other employees. Other employees are complaining about it. This is, essentially an undue hardship on us for you to not work on Sundays. We get the thing about observing the Sabbath, but just not something that we can accommodate here. Go find a job that can accommodate it, essentially. So that's the facts of the case. I get less questions, and you all probably have less questions at your workplaces about religious accommodations than you do disability accommodations. But the framework for accommodations is pretty similar, with a couple of key differences, which we'll talk about. But Title VII for religious accommodations requires workplace accommodations for sincerely held religious beliefs. The sincerely held religious beliefs part of that is kind of like the disability part of that, and that the first step is confirming that a disability or a sincerely held religious belief exists. For disability accommodations, most of us know now that basically everything is considered a disability, since they amended the ADA to allow, temporary impairments. Sincerely held religious beliefs, has always kind of, in my mind, been a little bit stricter, and one that's sort of definitely worth looking into, particularly if you've got suspicions and it's not something as obvious as, hey, I observe the Sabbath, I take off Sundays. Like, everybody knows, that's a regular, observance of a fairly mainstream faith. But sometimes you'll see requests, and we saw a lot of them related to workplace vaccine requirements and things like that. During COVID, we saw some bizarre requests and bizarre belief systems, and you'll get employees that send in things like vegetarianism, things like that are more kind of moral, philosophical type beliefs that they claim are sincerely held religious beliefs. And there's a whole body of case law about what sincerely held religious beliefs are. That's kind of beyond the point of today, but just flagging it as something to keep your eye on. So accommodations are required if it's a sincerely held religious belief, unless the company can show undue hardship. So just like the ADA there. But in the context of religious beliefs, it's been easier under previous precedent to show hardship than the disability context. And basically, the employer can show an undue hardship if they can demonstrate that the requested accommodation would be more than a de minimis cost. So, I've always kind of taken that to mean, and I think for the most part, the case laws backed it up, that that's kind of like any cost, like, as long as it's not completely absurd, like any cost, financially, operationally, whatever the case may be, to the employer, that's going to be an undue hardship. And so a lot of times in this religious accommodation analysis, the undue hardship has been a very lenient standard for employers. The plaintiff in this case, Groff, is challenging specifically that standard. That's what the case is all about, this de minimis standard. And it's gone all the way up to the Supreme Court, and the Supreme Court has taken on the case, which, if the Supreme Court has the ability to decide whether to take the case or not. So everybody gets nervous when the Supreme Court agrees to hear a case that they're going to change precedent. And experts are really thinking that that they are going to change the standard. So you can go ahead to the next slide, Brittany. Basically, we don't know exactly, if the Supreme Court says that we're going to change the standard and make it something more strict than de minimis costs, we don't know exactly what standard they'd implement. It could be something akin to what we have with the ADA. It could be that the plaintiff in the case is requested that the standard be changed to substantial cost or something along those lines. But a lot of experts are thinking that the standard will be changed. I mean, the plaintiff's argument in this case, and some experts' argument, is with this kind of de minimis standard, it basically renders religious accommodations as a non-issue in the workplace. I don't know if it's quite that drastic, but it's definitely a very lenient standard for employers. So if the court rules in favor of the plaintiff, it's going to be much more difficult for the employers to deny requests for things like schedule changes, prayer breaks, modifying workplace duties to accommodate religious beliefs. So this is a really, really critical one. I mean, we're going to know this very soon, and I'm sure we'll post something on our blog about it. But this is going to be a critical case to keep an eye on. The Supreme Court is also, I'm sure you're aware, deciding a pair of cases concerning affirmative action in higher education, and there's probably not been. Well, there have been, but it's a very, very sort of important cultural case before the Supreme Court. Will be one of the most important that's decided in 20 or 25 years, I would think. They're set to decide whether or not it's legal for colleges and universities to make race-based admissions decisions, essentially, with affirmative action policies. And this isn't not an employment case in any way, but what the Supreme Court says about those policies could filter down to organizations more broadly. It could impact some DEI efforts at some really progressive companies with respect to their hiring practices, particularly those with very robust affirmative action policies. Most DEI initiatives should still be lawful and unimpacted, even if the Supreme Court says that affirmative action is unconstitutional. But there are definitely aspects of the DEI policy that could be viewed as problematic, and it could be a future area of litigation. There's already been litigation about DEI policies and whether they're reverse discriminatory and things like that. So not an employment case, but another thing the Supreme Court's going to decide. That's you'll hear about it. It'll be plastered all over the front page of the New York Times and the Wall Street Journal. So you'll certainly hear about that one. I have also included on the next couple of slides. I actually just borrowed these from my February presentation for those of you who weren't here or who are new today or something, or may have not caught this the first time around. But there's a couple of other things that have happened. The Pregnant Workers Fairness Act was passed. Not a huge development, since we already essentially had the protections under the South Carolina Pregnancy Accommodations Act. Chris has gone into detail about that in previous updates, but just letting you know that it's out there. I've been getting questions about the Department of Labor updating their independent contractor test. They've got a proposed rule. Actually, I sent an email to one of my clients last night that's been tracking this, and apparently the Department of Labor said in a very recent court filing that this rule is not going to come out until October now. And essentially, it's going to make it a lot hard if this becomes a rule and it looks like their proposed rule. It's going to be a lot more difficult for businesses to classify workers as independent contractors in the Department of Labor's view. So for those of you that use independent contractors, which I feel like most of my clients use at least somewhat, that's going to be an important thing to keep an eye on. Next slide. And then the Pump Act and the Speak Out Act, again, we've already discussed on both our blog and on previous webinars, but I've included that here for you as an update as well. I didn't have a slide. I got one more thing. I did not have a slide on this because I saw it last night when I was, I read about it last night when I was sitting in bed, but I thought it'd be something good to bring up on today's presentation. And it's an article in the Wall Street Journal about marijuana use in the workplace, which is a topic that I feel like blogged about and done just presentations on that topic quite a few times. But the title is Boss's New Task is Figuring Out Who's High at Work. And it starts, more Americans are using marijuana. Their employers are trying to decide how much that matters. 1 in 6 American adults now say they smoke marijuana, a share that has eclipsed the number of cigarette smokers. So you think about cigarette smokers that you have at your organization. There are more people at your organization that are probably fairly regularly using marijuana. Obviously, the legalization efforts, it's still not legal in South Carolina. Legalization efforts have had a big impact on that. But according to a recent Gallup poll, more companies are scrapping certain aspects of drug testing policies. I'd be curious to hear how your organizations are addressing that in the chat. I think it'd be useful to know. Anecdotally, I've had a lot of clients do that. It is very, very industry specific as far as what my counsel to clients is about this type of thing. It's to sort of be taken very, very seriously and really thought through. But what the article says is that many are leaning on managers to spot signs that workers are impaired on the job and determine what to do when they are. They quote an employment lawyer in here, says it used to be you test positive, see you later, says Eric Mack, a partner with Littler. Managers are really on the front lines of making these determinations. And it's very difficult what to do. They give an example of a company that recently ordered a drug test for an employee where marijuana possession is legal in Virginia. After the worker drove a forklift into an overhead door, the worker was fired after testing positive. And, there are still cases like that with post-accident drug testing where, it's perfectly fine to do that. And are sort of very clear cases that aren't going to get you in trouble. But a lot of these laws that are being passed, in other states across the country, do have some protections for use if it's based on a medical condition. I think I saw Minnesota maybe was the most recent state that approved it, and they've got a provision in there about off-duty use, that you can't discriminate against somebody just based on their off-duty use. And as we know, the testing of this is difficult because it stays in your system for so long. So the point of this article, it's an interesting one. I encourage you to look it up. It's got a whole section on lunchtime pot breaks and people that much like having a cigarette break at work are taking lunchtime pot breaks. I encourage you to look it up and read it. The main point of the article is that frontline supervisors and managers are being asked to basically be on the lookout for this and try to detect it. And that's comes with its own set of, I think need for training and stuff like that, because it's fraught with legal issues when you put managers in that position of of sort of not snooping, but sort of closely monitoring that type of thing. So I thought that would mention that as well. I was reading that last night, and I thought it was too good of an article in the Wall Street Journal not to mention. And it's one that, I guess as many questions about as any of these other topics. So I think that's all I've got today. I finished up a few minutes earlier. Let's see if we have any questions. I do have a question about, much like the Department of Labor independent contractor test. There's also a question about the Department of Labor's proposed increase to the overtime threshold. I don't know what we don't have an actual rule on that yet. I don't know what the most recent update is. I looked specifically for independent contractor because I had a client question about it, and I sort of came across that court filing. But you usually don't know with these things until they give you some information. So as of now, no, we don't. Have any of the states that passed marijuana laws also passed a law to limit an employer's liability for having an impaired employee at work? Not to my knowledge, but that's a great idea. I think you'd be a great lobbyist for the manufacturing industry, for the Manufacturing Alliance or the Chamber of Commerce. Because I mean, if the laws are going to be such that employers are subject to liability for terminating people, then, if there's a third party lawsuit because somebody was high at work, driving your truck, I mean, should there be, tort reform legislation addressed to that specific issue? I think it's a good idea. I mean, I represent companies and employers, so, I certainly would think that, but I'm not aware currently. Any of my colleagues around could jump in. I'm not aware currently that any of the laws limit liability for employers. What a lot of the laws do is say that, make clear that the laws do not otherwise affect like an employer's lawful application of its policies and procedures. So in other words, if you've got a safety protocol that's violated, and by somebody, for instance, that wouldn't be affected by the law, which I think makes sense. So Jennifer says that they've got their supervisors taking an online course called Reasonable Suspicion, so that they're trained to recognize any impairments and what to do about it. I think that's a great idea. I mean, I think the training of that was kind of the point of this Wall Street Journal article, is that most managers and aren't trained on this and aren't equipped to do it. So that's great to hear, and that's good to know for the others on the call that resource is out there. This is a good question. Does safety play a role in religious accommodations? Meaning, if someone requests extremely long hair, beard, but in their role, this would be an issue of safety. Can the employer request that they, tie it or keep it to a reasonable length or whatever? Short answer is yes. I mean, safety would be a critical thing in an undue hardship analysis, and to me would be probably even more so than financial cost, maybe a stronger undue hardship claim. You just got to be prepared to sort of back it up that it is a sort of legitimate safety hazard. Right now, with the standard as it is being more than a de minimis cost, I think it's, sort of I won't say a slam dunk, but it's a very good case. It will be harder, even in safety considerations. If the Supreme Court changes the standard, it will be harder to make that undue hardship case. Just scrolling here. they've got a company, I think it's company policy prohibiting using Chat GPT for security and compliance reasons. Is anyone else seeing this as well? Yeah, I mean, I think that, I haven't really thought through all of the permutations of, outlawing its use. I mean, I think that you certainly can limit its use for performing the activity with which you're hired to perform. In other words, at a law firm, I think it would be reasonable for the law firm to prohibit me from using Chat GPT to perform lawyer activities. I mean, that would be a professional liability issue for me as well, but even sort of within the company, I think that would be a reasonable thing to do. So yeah, there probably are going to be a lot of companies also restricting employees' use of it to try to perform their jobs or make their jobs easier. So that's a great idea. All right, I think that's all the questions I see. I just want to thank everybody for being here today. Y'all let me know if you have any further questions. You see my contact information there up on the screen. Just a reminder though about the blog, because that's how you find out information about our webinars. We usually take a little break during the summer, and so I think we're on break until the fall, but sign up to the blog to know for sure, and we'll be updating some of these developments that I discussed today. So thanks everybody.
Thanks for joining this webinar presented by Haynsworth Sinkler Boyd. To learn more about the firm and its services, visit hsblawfirm.com.